Wait, how did you find me?
Public record?
I'm trying to hide. Man, trying to be private these days is like impossible. You got to protect your records. Otherwise, people just go online, they Google you, and they find you. They find you when they want to sue you. They find your records for anything. I got to do a better job of learning how to actually get my information private so that I can own nothing but control everything, and nobody knows that I don't own it all. So I thought I was private, but you found me on private record. So I got to do a better job of figuring out how to protect my privacy. I don't want everybody knowing what I own, how much I have, and it's all out there. So we're going to learn how to actually protect your privacy. So join me for this training and we'll see how this works. Well, we're joined today with Kurt, and we're going to talk a lot about protection and also privacy. And I think that's an important thing because we live in a digital age where information is very easy to get. If you're an attorney, you can pretty much get information from anyone, anywhere. And if you want to sue somebody, it's not hard to do that. So, Kurt, thank you so much for joining us today.
You bet. Thank you for having me. Appreciate it.
Absolutely. So where should we get started here?
I thought maybe I would talk a little bit about the use of LLCs and the use of trusts to provide some anonymity with regard to the ownership of certain assets. I was going to talk a little bit about myself, and I'm only doing this, I guess, as a nobody better to throw under the bus than me. I've been a practicing attorney for 27 years. I'm a litigator, which is one of the attorney-created words for I go to trial, I sue people, or I defend people in lawsuits. I do other types of work as well, but I do quite a bit of that. As a matter of fact, I had a court hearing this morning. We're online now, so it makes things much easier to be in two places at once. But generally, just to let you know how I wanted people to know what goes on in my office. And it's not a situation of being proud or it's just how it works, and it's how I've been taught. Generally, a client will come to me and a client will indicate that they would like to bring a lawsuit against somebody for whatever that particular case, breach of contract or some other wrong that they feel as though they've been committed against them. And so they'll bring that suit to me, or that they'll give me the name and the information. And then I talk to them about proceeding forward. What do we want to do to proceed forward? And a lot of times they'll say, well, I'd like you to take it on a contingency. And I said, well, yeah, a lot of people would like that too, but that's my money, not your money. It's my time. And I'm not really, I'm not necessarily in the business of giving away my time, of working for free. I want to know that there is a pot of gold at the end of the rainbow. A lot of times I want to know whether they have an insurance policy, because that would be the first line of defense. That would be the first thing I would look for, whether or not they have insurance. If I can figure that out. I may not be able to figure that out, but if it is a residential home that I might be suing over, or something that they own, I got a pretty good idea it's insured. And that's usually the low hanging fruit. Beyond that, a lot of people think that we attorneys jump to an asset search really quick on people. Asset searches are kind of expensive. And for the most part, when evaluating whether or not to take a case or whether or not to sue somebody, we don't invest in asset searches. What we do generally is we go online to that county assessor site and we look for those people's names and we type them in. And we've been doing this for years. It's what I was taught to do ever since computers came online. Since I've been at this for 27 years. It was a lot harder back when it was not computerized. But I can kind of figure out, hey, where does this person live? Do you have any idea generally where they live? And then I'll go to the county where they live, or the counties roundabout where they live, and I'll type in their name. And I'll just see, if they're out there, if they own property. And I cannot tell you how many times I have found somebody, their name. There it is. In fact, and so it's like, well, they own a home. And I can't tell you how many times I found that they own a couple of homes sometimes, or their names are all over it. Or I'm able to find their quitclaim deed with their phone number and other information on there that shouldn't be out there. It has no business being out there on public record, but it is. I'll also go to the Secretary of State, and I'll also type in their names under the officers, directors, owners, managers, wherever I can do, see what I can find, see if they own something. The reason being, I want to know is if this potential person who I'm going to bring a lawsuit against, if my client has a good chance of recovering. And really in my mind, in the attorney's mind, what we're looking for, we want to know if you have something to lose. That's really what we're looking for. We don't necessarily think we're going to take your house from you, but I want to know if you've got something to lose. I want to know if I can put you in a bad spot, or if I'm going to be able to work out some type of a settlement for my client or something like that. That's really where I'm pushing towards. And then I can go back and have a frank discussion with the client about, look, this person has a lot of assets. This is somebody who I'm willing to, work for you on. I might charge a little bit less if this person has a high net worth, or they have a lot of assets, or I found the house in the particular area that I want to find the house in. Or I've done a search and found nothing on the person and said, look, I'm not doing anything on a contingency. You're going to pay me hourly. It's going to be very expensive for you. You need to really think whether or not you want to pursue this. That's just the judgment I make based on what I find online. I could be all wrong, but that's not the business I'm in. I mean, my business is to represent clients and to give them information going forward and see if they want to pursue it. And if I'm able to find assets right out of the gate, then that's something that I become a little more interested in. And that's something that I can discuss with my client a little bit more. I'm not necessarily proud of that or say one thing or the other. I just want you to know that's what the attorneys are doing. That's what we're looking at. That's where we start. We're trying to find that information. I don't mean to offend any of my colleagues, but the reality is that's what we do. And if we can get somebody who has significant assets out there, or that their name is on property, now I know that they have something to lose, and that's somebody that's not going to like the lawsuit much more than somebody else who is really a bankruptcy potential, that they can just file bankruptcy on me. That really is kind of the worst outcome for most of us attorneys, where we get nothing. So we want to look that up, and then that's our first thing that we do. So me, as a practicing attorney and talking to my clients about protecting their assets, the first thing I say is, get your information off public record if you can, because that's the low-hanging fruit. That's exactly where we go. And it's the cheapest way to find out whether or not somebody who's going to be involved in a lawsuit has something to lose. And so that's the reverse thought process of it all, is that we don't want our information out there on public record if we can avoid it. Now, a lot of us have privacy concerns because we just don't like it. We don't like our information out there. And for good reason. We shouldn't like it. And there's no reason to enjoy that. If you do public searches here in Clark County, Nevada, where I'm at, Las Vegas area, if you type in Donald Trump, you'll find all kinds of information on Donald Trump. He wants his information out there. He doesn't care. But most people aren't situated that way. We don't want our information out there. We don't want to invite a potential predator out. We don't want them coming around, and we don't need that. And particularly when we do have something to lose, and it may be a significant asset, a second residence or something like that, that we can't protect in a homestead bankruptcy type action, which you can protect your home residence in most jurisdictions, then it's problematic. It's worrisome, particularly if we have a rental or a property that we intend to flip at some point. But if we have renters in there, there is a high likelihood that we could get a lawsuit on a breach of contract, breach of lease. We have to sue them because they've decided they're not going to pay us rent because there's a moratorium and they don't have to. And we try to sell the property out from under them, and then they bring a lawsuit that they're being displaced or whatever that case might be. We have lots of ways that we can be pulled into lawsuits that on no intention of our own, other than just trying to stay in business or trying to utilize our property for the very purpose that we invested in it. And so it is of a concern to me. So how can we take some steps to avoid having our name out there in the public? How can we take some steps to protect ourselves? One I brought up, and I'm certainly not an insurance salesman, but insurance is a first line of defense, and we need to have adequate insurance over our rental properties and over our homes. Why do I say that? We attorneys love insurance companies. We attorneys love insurance policies because we know that we're going to get paid. We attorneys generally will settle cases within the limits of the policy. We call that within policy limits. We want to take that easy money and get out of the case. And I don't want to go after you personally because it becomes very expensive for me to chase you down personally. So if you have a policy of $350,000 on a rental, I'm going to recommend to my client that they take whatever amount is less than the $350,000 of the policy to settle the case. That is my first recommendation, because if you want me to chase these people down, if you want me to get a judgment and go to trial, I'm going to charge you 50% of the money as opposed to my 33% normal or my 30%, whatever that happens to be. If you want me to go to trial and get an excess judgment, if you want me to go after these people personally, that's going to cost you 50%. And sometimes it's upward of that, to be quite honest. Sometimes it might be 60% of the recovery. And I have to pitch that to my client. You got to think about this before we go in, because I'm doing a retainer, and retainer words for us is contract. So I'm going to lock you in on this. And if you want me to go after these people personally, you're going to pay. And we're not going to renegotiate this contract after the fact, because it's very labor intensive to go after somebody. So my first point is have adequate insurance. And most attorneys want to just take the insurance. Most attorneys are not vindictive to go beyond that. There may be some clients that are, but it's usually not a good business proposition to go beyond the policy limits. But if they do, anonymity can be very, very important, even if you have insurance. And this is the way that, and these are the ways that I want to talk about that. First is through the use of a limited liability company. And the second is a land trust. Let me talk about the first way, because the first way most of us know about limited liability companies. A limited liability company, they're relatively new in the law. They've kind of come about in the last, in 1986 is when we got our limited liability statutes here in Nevada. So they've been around since the 80s, kind of, and it's kind of the newfangled thing. At law, that is a rapid thing, rapidly developing area. I know that's 50 years old, but it's kind of a new thing to us, or whatever the case might be. So these limited liability companies are a hybrid of a sole proprietorship, or us just being in business on our own, and a corporation. And you've got to take all the best parts of being in business on your own and merge those with a corporation without all the formalities of a corporation. And we hatched the limited liability company. Limited liability companies have managers that manage them, and they have members that own them. And we attorneys invent these words so that we can charge people more money, so that we can run up our bills. But that's what they call them. There's a manager that runs it, and there's a member that owns it. In a corporation, it's a board of directors, it's a president, it's a secretary, it's a vice president. And that way we know we're talking about a corporation versus a company. If you hear the word member of a company, that's the owner. If you hear manager, that's the manager. They're managing the property. In most jurisdictions, LLCs can be either managed by managers or they can be managed by the members. But warning, if you don't have a manager, that will expose you as the member to a public record, potentially in the filing on the corporation. So in Nevada and many other jurisdictions, but I'm speaking to Nevada because that's one I know best, only the manager needs to be on public record. So if you list yourself as a manager of an LLC, I might think you own it, but I don't know, because you're not a member. So if you call yourself a manager, I'm not sure whether you own the thing or not. That's a good thing, because now I don't know, and I'm going to have to do some investigation. And investigation in legal terms is expensive. That costs a lot of money for me to figure that out. So that's one good thing, is to name yourself as the manager over naming yourself as a member. I would prefer that you have a third-party manager. I don't care who it is, but somebody whose name you can use that's not yours on your LLC, and somebody that's not your spouse or that carries the same name, or one of your children. That's a bad idea too. Don't leave me breadcrumbs to find my way back to you. I need some third-party buddy or somebody who's a friend who can go on there on public record as the manager only. And that way it doesn't point me to you. That's an important thing to point out. In addition to that, when you have an LLC, you don't have to have annual meetings. You probably should keep minutes, because it's really a good idea. You don't have to pay salaries, but you might need to occasionally put some money into a bank account and take that money back out. You need to have operating funds in the account that justify the LLC. It's got to make sense. If I have overhead of $1,200 a month, then you need to have $1,200 a month in your account. And it's good to see that money coming and going in case somebody tries to pierce your LLC down the road. And we'll talk about that in a couple of minutes. But those are good rules to have and to know, to maintain some the ability to keep that looking as though you've got money coming in and out. That's very important. You can keep minutes and you can keep other records, and you have to do a corporate filing every year, but you can be taxed as a corporation or you can be taxed as an individual, as a sole proprietor. They allow you to go either way on that. So you get the best of all worlds with an LLC. Super important. And on public record, not in every jurisdiction do you need to list the members. Some jurisdictions require that. I don't like those jurisdictions. In Nevada, the members are not listed on public record, so we never know who the true owners are. We only know who the manager is. I'm the manager of a couple of companies here in Nevada. If you were to look me up on the Secretary of State, you would see that I'm the manager. It doesn't mean I own the company, and I'm telling you right now, I don't own the company. If anybody wants to do some investigation, we call that discovery for the lawyer talk. That means I file a lawsuit, I spend a bunch of money, and I start asking questions. If somebody comes to me and they want to know who the members are, I'm going to tell them, I don't really know. I do know, but I can't tell you because I got a contract that tells me I can't tell you. So I'm not really going to be too forthright or too forthcoming about who the members are until I get a court order that directs me to disclose who those members are. Once they get there, it's probably going to be about 18 months down the road. And my members were doing all kinds of things in the meantime. I don't know what they were doing. I was telling them they were asking questions, but I was having some memory issues, some vertigo set in, or whatever the case happens to be. But I'm never real forthcoming about who my clients are or what the members are, or any of their personal information. And so that's the ability that you have to shield your ownership or to shield your name, or grant you some privacy by way of the LLC. Do you need to file a tax return with your name on it if you're the member of an LLC? You might. Does the filing of a tax return mean that you own the entire LLC? It does not. You might be a 5% owner and sign that tax return. You might be a 2% owner. I don't have any idea. It's going to take me a while to figure that out. Again, that's very expensive for me to figure that out, but it is just something to remember. On a mortgage, might you be listed as the obligor on a mortgage? Yeah, you might be. If I get a hold of that mortgage, I might get that figured out. But it still doesn't mean that you are the owner just because you pay for it. Yes, it certainly would seem so, but it doesn't necessarily mean that you are. You may be the one cutting the check. You may have other members out there who are part of that. We have a super famous case here in Nevada that went to trial, and our Supreme Court ruled on it. And what it was there was a very nice lady who owned an Italian restaurant in Northern Nevada, and she had a judgment against her, and they came in and they seized her bank account. And they took the bank account, and then that went up on appeal to the Supreme Court. They said, look, you can't take her bank account. She had other people's money in there. And the Supreme Court wanted to know whose other people's money was in there. And well, my family members were in there. We're all owners of this business. And the Supreme Court forced them to give that money back, put it back into the account, and for them to have a trial to figure out whose percentage of money was in there or who owned what percentage of money in there. Well, her family members all came to court and they all said, well, that was my money. That was my money. That was my money. Turned out she had like 5% in there. I don't really know the truth or the falsity of any of it. I just know that you just can't go around seizing accounts if you don't know they're the sole owner of the account. And so that's very important to note, because most courts will not allow you to execute your judgment against a bank account of an LLC unless you know exactly whose money is in there. And that can be very difficult to prove. So again, it presents a lot of hurdles to have an LLC. So these are kind of some important things, that you can have an LLC Keep the documentation private, keep your ownership private. It may only be you, but I don't know that. We have this saying in law about evidence that a brick is not a wall, and it isn't. So just because you pay the mortgage, that might be a brick. Just because you file the tax return, that may be a brick, but it's not necessarily a wall for me to go into court and say, look, I'm going to seize all their assets, or I'm going to make them pay me on a judgment. That's not going to get me there necessarily. So that's something important to remember, just in case, that a brick is not a wall. And although I may have a pretty good idea, you're the owner, a good idea is not enough when I go into court. And I'm going to keep telling my clients that. I need more than just an idea. I got to know that it's theirs. I have to know that before we get you paid. And so that's where that expense comes in, where I'm back to, you should have took the insurance policy. Okay. You should have done it. And I'm telling you now. And then I get the conversation afterwards. Why didn't you tell me just to take the insurance policy? No, I did that. I told you. I should have had my GoPro sitting there when I told them and filmed it, because, and I've been tempted to do it from a time to. I want to make sure I get you on video saying no, because I'm going to hear later about, I told you so, and you're not going to like it. So that's the LLC. Love LLCs. They're very useful. They're very handy. Do want to point out that LLCs are public. Managers are generally public. In some jurisdictions, members might be public, but it's not 100% of the membership that's disclosed. I have to do a filing fee every year with an LLC. In some places, I have to get a business license. I have some regulatory body I have to answer to, the Secretary of State. That costs me a little bit of money. That's the cost of doing business. It's something you need to know about. Secondly, my second recommendation is to use a land trust. I love land trusts, and I think that they are, you can almost achieve almost all of the same benefits, maybe get more benefits out of them, or maybe get less. It depends on how you look at it. We'll do a compare and contrast a little bit with an LLC in the future here, but land trusts are I call them contracts between the owner of the property and a trustee and a third-party beneficiary. What do I mean by all that? I own some real estate and I want to put it into a land trust. I don't want to be the trustee because I don't want my name on the title. When somebody does a title search, they'd find my name. I don't want that. So I'm going to find somebody, not my last name, to act as my trustee, my third-party intermediary, as it were, my agent, or in some cases, when we talk about LLC talk, my manager, who is going to be there on my trustee, who's going to be my manager, my trustee. We call them my trustee of my trust. And that's a person who I don't want to be my last name. And it's an individual who's got to be over 18. And it's somebody that can't be crazy. I guess those are like the requirements. So if I find that individual, a brother-in-law, or somebody that doesn't carry my last name, or a close friend, or someone who is perhaps a fiduciary or an attorney who I can pay, it is going to cost me some money necessarily if I don't get a friend to do it, then their name will go on public record as the trustee of the trust. And trustees do not own the property. Trustees don't own it. The trust holds the property as though it were a basket, much like an LLC is a basket. Property is inside of that basket. The owner is holding on to the basket, but the trustee is directing what the basket does or where it goes, and the trustee has to sign any documentation that needs to be signed. The trust is also going to have beneficiaries. Me as the owner, if I pass away, I want this property to go to my kids. So I'm going to set them up as the third-party beneficiary. And in my trust, I'm going to tell my trustee, if I die, give the property over to my kids, hand the basket over to my children, and walk away. That's all I need you to do. I need your name on public record. In case somebody checks the assessor's website, it's going to come up as you. And in my particular case, I'm the trustee of a few trusts. You would see Kurt Harris as trustee for the Lazy Dog Trust. Now, again, somebody might think I own the Lazy Dog Trust, and a brick is not a wall. I don't own it. I'm just holding on to it. I'm holding it for a friend. That's all I'm doing until the friend tells me what to do with it next. And that's all that I'm there for. And if somebody comes to me with a lawsuit, for instance, I have a rental property. I put it in the trust. I have a rental property that's symbolized by a deed. I've put that into a basket of a trust. The deed is sitting in the basket. I'm holding onto the basket because my friend asked me to. I've gotten a lawsuit now in the name of Kurt Harris of the Lazy Dog Trust, and I just got served. The first thing I'm going to do is call up my owner friend or my owner, whoever that happens to be. I just got sued. What do you want me to do? They say, send it over to me. And I say, okay, I'll send it over to you. I send it to the owner. They send it to their insurance company. And hopefully that's the end of it. But that may not be the end of it if somebody's vindictive and they want to go beyond the insurance company, or they want to find out who really owns the trust. In that particular case, they might initiate or press forward with the discovery of the lawsuit. Me as a trustee, I have a trust that tells me don't disclose the owner. I'm under a contractual duty not to disclose the ownership. So in that particular instance, I don't want to know the owner. I don't really care. And I don't ask too many questions. My name is on public record. I've been served. Now they're going to depose me. And I'm in a deposition, and and nobody wants to go to a deposition. Don't get me wrong. I'm not being cavalier about this. Sitting in that hot seat, bunch of attorneys full of hot air, asking you stupid questions about your background. They want to know information about you. But then they get down to the question, who is the owner of the trust? And I say, I'm contractually bound not to disclose the identity of the owner. They'll say, we're going to go to court. We're going to compel you. And I say, okay, that's what you have to do. You do that. But I'm not going to disclose the owner. And I don't have to, because I got a contract that says I can't. And I need to abide by the contract. I'm not going to get in trouble. And the owner in the trust has said they're going to take care of me if I do get in trouble. They're going to pay all my fees, so I don't need to worry about that. But they'll go back to court and they'll get a subpoena or some other order compelling me to disclose who owns the trust. When I get that order, I'm going to tell my owner friend or whoever owns the trust, I got an order. I'm going to out you. I'm going to say your name. So you need to know that's coming. And then I will, and I'll disclose it because I'm under court order to do that. However, my client now has had 18 months or 24 months to prepare for this, and they have seen it coming. And this is the frustrating part about me being as an attorney, is that I've been working to get this name of the owner for 18 months now. And then I find out the owner just put a new roof on the house. The owner just pulled some second mortgage out of it to do some plumbing and some electrical. And now he's upside down in the house, and there's a mortgage out there. And now there's nothing for me to get. And they've been seeing me coming for the last 18 to 24 months because the wheels of justice grind so slowly that they've seen me coming all along. And at the point where I get to somewhere where there is a pot at the end of the rainbow, now the pot is empty because there is a new roof on the house and there are debts and they are substantial. And the owner has said, look, here's the situation. The house is upside down. And if you want it, I guess you can take it with all the debt. Or how would you like to take $10,000? How would you like to take $20,000? How would you like to do your client a favor and settle the case? And then I have to go back and have the hard discussion with the client again when I'm on the other side of it, because that's what it is, and say, look, here's the situation. The house is upside down. We just found out. We got through the trustee. We got through the barrier. I found out who the owner is. But in the meantime, the owner did some bad things. And they said, well, can't you get in trouble for that? I'm like, well, yeah, I guess. I don't know. No, probably not. I'm not going to, I'm not the trouble police. I'm not going to run them down. Well, can we call the cops? Go ahead. They don't care. I mean, there's just no recourse. And it causes you to pull your hair out. Obviously, you can see I got a little bit of hair because I don't chase those rabbit holes anymore. I learned those hard decisions years and years ago. And then I tell the client, just take the $10,000, just take the $20,000, just take the settlement. It's the right thing to do. I promise you, you won't regret it, or you will regret. You will regret it. You can blame me later, but you're going to be better off. I promise you. The point I'm trying to make is when you have anonymity, it's very expensive for me and my colleagues to figure out who you are. And along the way, you see us coming. And when we get there, you have leverage. And that's really what I'm really trying to sell here, what I'm really trying to promote. It isn't that I got over on anybody or you beat anybody out or you beat the system or you caught a loophole. It's none of those things. It's that when we got there, you had leverage in the negotiation and you were able to manage your risk beyond your insurance policy because I didn't know who you were, because it took me a long time to get there, because you had a trust, a privacy trust, or because you had an LLC. And those are some of the methods where it just was very expensive for me to get to you. And it really wasn't worth it when I did finally get to you, because you were able to negotiate with me in such a manner that, believe me, I understand that kind of negotiation. I understand that you're hanging a potential bankruptcy over my head or something like that, because you've had all kinds of time to prepare, because you've been watching me for the last 18 months. And I've been plodding along through the public legal system, and you have seen every move that I have made, and you have watched my clients spend money, either my time or their money, all along the way to get there. And so what is best here? What is the preferred method? I like trusts because they're not public documents. Only the title is recorded and your trustee's name is public. Your name is not public. I like those very much, but they are much more of a smokescreen, or they're much more of a shield, as I like to say. They shield your identity. And I like that a lot, because if I don't know who you are, then I can't necessarily come after you. And you can hold me off for a long time. Will I eventually figure it out? I hope so. But will it be incredibly expensive? Yes, I promise you it will be expensive if I ever figure out who you are. An LLC, on the other hand, a little more expensive to maintain. And we liken that more to a shield and a sword, because there are limits of liability in an LLC that you can push back and say, look, I got 5% of this LLC. You want to come after me? Come after me. But I'm only at risk for 5% of whatever the value of the home is. And I've managed my risk that way. And so I'm able to use an LLC as a sword and a shield, whereas a trust is just a shield. You just shield the identity. But a trust can be much more cheaper, and there's no management fees. There's no annual fees. It's a one and done cost. And so I like that. So you see me vacillating back and forth between what's best or what's not best. It depends on what's best for you. I had a client that had 32 rental properties, and those clients came to me, a husband and wife team, and said, look, we can't afford 35 LLCs. You understand that, don't you? And I'm like, yeah, it's a managerial nightmare. I understand that. I don't know how you could juggle all that with all those rentals. And they said, we got to get into something different. And that's when we migrated into real estate privacy trust or land trust. We put those properties all in trust, shielding their identity, and then had the owner of the trust be an LLC. So we kind of did a layered protection type of structure, so that they still had one LLC or a couple of LLCs that was a little more affordable or a little more manageable for people like me, because it's ridiculous having to manage all those if you have substantial rental properties. And then all these trusts, well, it's a one and done. You can forget about it. Once it's drafted and signed and the property's in it, you can be done with it. On both of these entities, you can buy and sell land in and out of them. You can sell them with the land in it. If we come back to my basket analogy, I have placed the land in the basket. The deed is in the basket. So in a trust, I'm going to sell you the basket, and I'm giving you the land. It's free. So it's all yours. The basket is really expensive though. And so you're taking my basket with the land in it. In an LLC, it's very similar to that. I'm selling you the LLC. The only asset in the LLC is the deed, but I'm selling you the LLC and not the land out of the LLC. So take it all, and I want to resign as a member of the LLC, or I'm going to resign as the trustee of the trust and turn that over to you, and you get your own trustee. And so You're able to buy and sell the property in and out of trusts and LLCs. You're able to buy and sell the property as part of it. And what that means is, in my lazy dog analogy, when I'm the trustee of the trust, when I sell that lazy dog trust, I'm going to resign as the trustee and they're going to put their name on as the trustee. But my owner's name never popped up on public record. They own the property. We sold the property. Their name never popped up on public record. So there are, if somebody has a deed restriction or something like that, they might be concerned with in a flip, then there was never a sale because I just sold a basket. So there's no reason necessarily to record the sale because I did the transaction by way of selling the basket and not selling the deed. Some people are comfortable with that. Other people don't like that type of transaction. It's a pretty slick way to do your sales when you're flipping properties. And that's something we may get into on another day. But the point is, having anonymity is a real winner when it comes to attorneys and when it comes to shielding yourself from a potential litigation where I never saw your name on public record. Some people say, well, my name's already on public record. Can I put it into a trust now? Or what good would it do? Because if you run your search, you're already going to find me. And here in Nevada, same thing. If I go to do the search, I'm not going to find you at first. But if I do history of the party, I'm going to see you. And I will see that on such and such a date, Bob Smith transferred the property to the Lazy Dog Trust held by Kurt Harris. I'm going to see that. Is that going to tell me that Bob still owns the property? No. Do I think Bob still owns the property? Yes. Yes, I do think that. But I don't know that. And again, we're back to the brick is not a wall. My suspicions don't go very far in the courts. And as a matter of fact, the judges laugh at me all the time when I say, Judge, you know, Judge. And they say, yeah, nice try. But no, go back and try again. Go back and get me proof that they own the property. And so there we are back to the 18 months or the 24 years, despite the fact that I've argued loudly and got red in the face. The judge says, no, that's just not good enough. You've got to be able to prove these things. And so that's where the cost comes in. And that's where I want to give you this leverage of having the anonymity. John D. Rockefeller, he said that, you know, the secret is to own nothing and control everything. And that really is what we can do with these trusts and LLCs, is that you haven't given up any ownership or control at all. But on public record, I don't see you. You're just not there. And why are you insuring this property, or why are you paying tax on it? Or why, you know, why? I have no idea. But still, it doesn't mean anything. Now, I may be certain that you are the owner, but again, that gets me nowhere in court. And so those are just some of the things that I wanted to promote and let you know that these are very important. It's very good to keep the people like me out of your life. We don't serve any good purpose. So if you can structure your lives, you keep me and the bloodsuckers away, it really is beneficial to you. And, you know, we get out there sometimes, we see your name on public record, we're just licking our chops. And you just don't want that. And so, you know, I love the privacy aspect of it for that particular purpose, and a whole other host of things that I can talk about down the road. But with that, I don't know if you had any questions or anything. I hope I didn't rant too much. I'm sorry.
Oh my God. No, that was awesome. I loved how you took it from both sides, and, you know, from the bloodsucker side and also the other side. That was brilliant on how you did that. It helped my mind wrap it around both sides. And, you know, I've kind of had to deal with this quite a bit with, you know, the higher up the flagpole you get, the bigger the bullseye in your back gets. So, you know, as we kind of climb through life, as we go on this journey of success or whatever we're doing and acquire more things, that bullseye is just getting bigger. You know, one of my mentors said, the higher up the flagpole you get, the bigger the bullseye in your ass gets, is what he says. And that's where the bloodsuckers come looking for you. And I just loved how you did that. Yes, we have a lot of good questions. Before we get to the questions, though, you know, you were talking about the trust, and you were talking about, you know, like the process of playing the game where you're making people wait and you're preparing while you know that war is coming. And I've read the book, The Art of War. too many times to count. It's a very easy read. I've just read it. And this one, I was looking through the statements and the quotes, but this one's perfect. To secure ourselves against defeat lies in our own hands, but the opportunity of defeating the enemy is provided by the enemy himself. You literally have just laid, I mean, think of that. Like, think of, that's the art of, like, that's the art of war. Sun Tzu. The book was written a long time ago. How perfect is that quote for what you were just saying? The
It's
enemy
perfect.
is providing its own defeat.
I can't tell you how many times that I'll sit with a client and I'll try to prep them for a deposition where the other side is coming after them and they give up all the information. They give it all to them. And I try to have this discussion and there's a lot of winking and nodding. And I say, the fish that gets caught is the one that opens its mouth. You need to remember that, because every fish hanging on a wall opened its mouth. 9 times out of 10, I get the information from the adverse party. They give it all to me and they give it freely and easily. And I don't understand that, but it's so true, so true. And that Sun Tzu book is so correct about that.
Oh my gosh. It was just, you said that. And I'm just like, there's a quote that this, you know, I couldn't remember the quote, but this is the one. It took me a little bit to find it. Just any of you that have not read The Art of War, you have to read it, because Kurt here literally just laid out the whole book in the strategy from both sides. So let's get to some of these awesome questions, because we got a lot of them here. And folks, be, you know, happy to put your questions in the Q&A. I'll be reading them off here. Let me just move it around. So the first one comes from Lynette. She says, is a family trust where we have our houses different than what you guys are talking? Wait, is a family trust where we have our houses different than what you guys are talking about? Not really sure how that's framed like that, but
I think she's thinking of like a revocable living trust that is like my personal family revocable living trust. Now, me as an attorney, everybody should put their personal residence in that trust because it avoids probate, and it's the place to put it. And this is the worst case scenario, but you're able to homestead your personal residence. You get to keep one. You get to keep that in bankruptcy. And so the bloodsuckers can't get your home out from under you. You can protect it. And so that's the point, is that you would put your personal residence in your revocable living trust, but you wouldn't put that second one in there, because now that I can seize that one. So I want you to put not all your eggs in one basket, not all your eggs all your eggs in separate baskets, and remove that out of your estate entirely, so to speak, by placing it into a separate trust. And some people call it a single purpose LLC, a single purpose trust, a land trust for just this one piece of property, and then forget you own it. Just divorce yourself from it.
Yeah, Kurt, you know, back when I was big into wholesaling, we used to do this a lot. We would use, you know, realty trust, we call them land trust. We would put the property under contract in the land trust, which didn't cost us much to open that land trust. And when we found a buyer, we just sold the whole trust. We're just like, here, you just take, like you called it a basket. And, you know, I thought it was brilliant because it just made the transaction so much smoother. I didn't have to put things in an LLC, do the bookkeeping, take them out. It was sort of just like, all right, here, just take the whole thing. And I've even done it with LLCs where we've opened an LLC and then sold the LLC with the property in it, but that's clunky. So I love that. And Yuri says, how do we take our real estate LLC and turn that into a trust? But I don't think you'd want to. You kind of hit this. Can you just touch on that? Because I think that's the whole art of war right there.
Right. Now, you don't necessarily want to do that. You can take property and put it into a trust and have that trust owned by the LLC if you want. If you're thinking about doing the conversion, it might be an expense issue or something like that. I don't recommend it, because now you might be taking it out of a superior vehicle that you've been holding it in and maybe putting it into something that for the purposes of I'm not sure, but you may consider whether or not to do that or not do that. But it would be just a matter of the LLC. If you wanted to do it, it's a matter of the LLC, the member of the LLC or the manager of the LLC signing a quit claim deed, quit claiming your property over to the trust. That's all that it requires. And then it falls off of public record at that point, and it's registered now in the name of the trust. You have to record that quit claim deed, but that's really all that it takes to make the transfer. And you can always go, this is another little, I guess, a point. You can always go from a an LLC into a trust without there being a tax implication, for the most part. You can almost always do the same with an LLC. But if you do it into an LLC, they might want to call the loan. And so you have the due on sale clause that could potentially be triggered if you don't go into a trust. A trust will never trigger a due on sale clause.
I didn't
But
know
going
that.
the other direction could potentially trigger it. Why a mortgage company would want to call the note, I have no idea. The only time I ever saw one do it, I didn't really understand it, but I got it later on. They said, well, this is a residential mortgage and they're only paying like 5% interest. And they're putting it into an LLC. And now we want to do a commercial loan for an additional 2%. This is a 7% on a commercial loan. You ought to know that. I was like, oh, you got to be kidding me.
Kurt, you think you guys are the bloodsuckers? The banks are the bloodsuckers, man. Freaking 2%, and they're doing a 2 months. Oh my God.
Because an LLC is a commercial loan. I'm like, oh, you got to be kidding me. It's the same house. That's ridiculous. So going into a trust is always okay on a due on sale. They can't invoke a due on sale clause, but going the other way, there is a potential of that, which always makes me a little nervous.
That's great, because we just covered Jameson's question. Jameson, I hope that covered that, because that was spot on exactly what you were asking about the due on sale clause. So I just learned something there. I did not know that moving it into a trust would not trigger that. I always was thought that it did. So that was fantastic.
I came
all right.
back. That was like there was an act, Lawrence St. Germain Act, that said you cannot invoke due on sale clause when going to a revocable trust or a land trust. So federal law.
So Will Friends was asking, can you explain a series LLC and the best way to use them? I'm not familiar with them because we can't use them in New York, but in Las Vegas, you guys use them a lot.
Yeah, series LLCs would set up for a series of properties. That seems to be an ideal vehicle. Again, you have those expenses that are associated with each individual LLC that you set up in the series. But if you have a series of 5 LLCs, you have a series of 5 properties. Each property is held uniquely by each LLC. However, you are assigned one tax identification number for all 5 LLCs. So it's a single tax filing. You still have multiple LLCs. You still have the multitude of expenses that are attached on, but you have the convenience of using a single tax identification number. That really is the big benefit of the series LLC. You might have same members and all the same managers, but you do get unique protection on each property, on each LLC, but all are jointly filed together. So I can't chase the second LLC for debts of the first one. I'm not allowed to leapfrog into the other assets, despite the fact they're in a series. I can only get my judgment against the one.
Okay, interesting. Yeah, they don't like those here in New York, probably because it's one tax ID number, and they like feeing us to death out here. So Candace is asking, so a really good trusted friend that supports your business would make a good manager, not just some willy-billy random person, correct?
Yeah, I believe that, correct. But someone who can have some memory loss when the time is necessary.
Memory loss.
Maybe, sharp at certain times, but maybe a little off at others.
Oh, I love it. And then Candace had a second question. When starting a business, should you have an LLC at the start, or is there a certain point that you get in business that you should start looking at having one? That's an easy one.
Yeah. It's always good to, it's always best to start with it. That's best. But what I normally find is that people, I don't know if this thing's going to work or not. I don't know what's going to happen. And I just kind of fell into it. I was working out of my garage, and then I moved for this, that, the other, and so it's always best to have the LLC up front, but that's not normally, it's not necessarily the norm. That is best, and that's the best practice, because you sign that lease when you were a sole proprietor, and now things took off, and now they don't want to get another lease from the LLC. They want to have you on the hook,
and they will not. I've done
and they
that.
won't.
Yes,
they won't let you get out. So you mean I got to change now? I got to go get a new place because they're not going to let me change my lease where I've been, no, not going to let you do that. Nope. So yeah, so that's why it's always best to start with it. Despite the fact that a lot of people don't, we're not going to criticize anybody for what they do, but it's always best to start with it.
Yeah, I made that mistake, Candace, early on in my career. When I had my skateboard shops, I opened them up and I did a lease in the mall, and I did it, just in a DBA, and I just didn't really. I was 17 years old, actually 18, and I had no idea. And then I went back to the mall after I got the LLC because my attorney said, "Oh my God, we need to get this in an LLC. You have liability if someone trips and falls after you mop the floor, all this stuff." And I went to the landlord thinking, "Oh, no big deal. Hey, here's an LLC. Can we modify?" Absolutely not. I went 5 years on pins and needles, wondering if someone was going to slip and fall. I actually told my staff, no mopping the floor until after hours. And I made everybody stay a half hour later. And it's funny, I have an intern who has been with us for a long time, and now he's a partner in one of the companies, but he just came to me the other day. He's starting a construction company. And he's like, it's like $1,200 or $1,500 to set the LLC up and all the stuff to do it right. I don't think I really want to spend that. I'm just going to do it. I said, you are absolutely insane. I said, spend the money. You'll thank me later. If you need to borrow it, I'll make a loan to you to borrow the money to do it. Don't step over dimes to pick up pennies is the easiest way to say that. Just do it the right way. Your bookkeeper will thank you. Your CPA will thank you. And if someone trips and falls or has something happen, you'll be the one thanking us for making that recommendation. Just spend the money. Jameson Clark said, if you put a friend as the manager, do they have the right or a stake in your company?
Absolutely not. And same with the trustee. Manager of the LLC is just a manager. Usually it's a paid position, usually, not necessarily. With a trustee, I think that most of the trusts, they want like $200 a year, $150 a year or something like that to have your name out there. They have no stake in the property whatsoever. The contract says so. And in attorney talk, managers don't own property. They don't own LLCs. It's kind of like the manager of Target. They don't own the store. They don't. So there's no reason to think that they do, despite the fact that a lot do. That's kind of like the perfect crime. I was the manager all along. Nobody knew. I was the landlord. I never said.
Eric's got a good question. He said, in formation of a trust, do I still need to maintain each and every LLC, or are they all properties lumped into a single trust?
Yeah, it depends. I think we're kind of talking maybe the opposite there. You could have a trust that owned all of your LLCs if you wanted to set it up that way for a probate purpose or something like that, or for some shielding purposes upstream as to who the actual owner of the LLCs are. My recommendation always is to have individual properties in individual baskets. If that's individual trusts, I hope I'm answering the question right. If that's individual trust, I prefer that. If that's individual LLCs, I prefer that. Is there any restriction on it? There isn't. And so I don't want to like oversell and say, hey, you can't put 2 properties in one trust. You can. Yeah, you can put 10 in there. I don't recommend it. I wouldn't do it. Just like I wouldn't put 10 properties in my LLC where I want to limit my liability. The whole purpose and point there is to try and manage my risk, to keep my leverage. That's the main thing. And so I don't want to put all my eggs in one basket ever. And I just don't recommend that.
Smart. Jameson said, if you name someone else on the trust as the manager, are you still able to pay yourself a salary to manage the trust? So if you have a manager, can you still pay yourself a salary if you're the owner of the trust?
Absolutely. Absolutely. Yeah. You're able to by use of like an LLC or whatever, you certainly could pay yourself. You'll probably be pulling dividends out, but you could set up yourself as a salary. You could be a co-manager. Nobody scrutinizes these documents, and they only come out when there's litigation. And so that's the only time that the paperwork ever really comes out. And so sometimes you're just keeping this paperwork just in the back of your mind thinking, well, some bloodsucker may be looking at this someday. So I want to make sure I get all my dates down, and I'm going to make sure I get all this documentation done, because when I turn it over to them, it's all going to be there. And so, it would all be on paper. And again, it wouldn't be public. You might be pulling a salary, but you could certainly be a manager. No prohibition.
All right. Theodore said, does the trustee have to be a resident of your state or the LLC state or a citizen of the US? It's kind of 3 parts to that.
Super good question. And the answer is doesn't have to be a citizen of the state or a citizen of the US for that matter. The trustee
really?
is just a person who's supposed to be directing the ownership and I guess the management of this particular piece of property. And it can be somebody who is out of the country.
And don't forget, they should be forgetful.
Yeah, very forgetful. But convenience wise, it's probably unwise to have somebody out of the country. And it would just, for me as an attorney, I would, I would make a stink out of that. I would make a lot of noise about that. I don't know if it'd get me very far. I don't know what good it would do me, but really what the trustee has to do, they're on public record, and they receive the mail. They forward it to you as the owner. And if they receive service of process, they need to, hand that over to you. If I have to serve somebody in France, I'm going to be bent out of shape. I'm going to try to make that somebody pay for that because that, but there's no real prohibition on it.
Perfect. Chris has a good question. I think a lot of people are probably thinking this because this crossed my mind. He says, so is it better to hold real estate holdings in a land trust rather than a corporate entity? So he's kind of doing an and or, but you're kind of talking about this is the way to do it, but it involves both. Can you just hit that one more time?
Yeah, and that's where I flip-flop back and forth, because I think that an LLC is best for a single property, period. I am going to pay for that, and I am going to make some public disclosures, and I do have to file the tax return or do a disregarded entity and file it and recognize it on my tax return. So then on a trust, I won't have to do any of that stuff. And I don't have to pay every year, and I don't have to register anything, and I'm not on public record, and I don't have to deal with a manager. I just name a trustee, and hopefully my trustee never has to do anything but sign the sales documents when I'm selling the property. And so I flip-flop back and forth on the better and best, because a trust may work out much better for some people than an LLC. Some people, it's just a hassle. I just don't want to deal with it. And then some people might think that the LLC formalities are best. When we talk about limits of liability under an LLC, if I put a house in the LLC and I own 100% of the LLC, my house is at risk. That's what I'm going to lose. If I put it in a trust, it's kind of the same thing. That's really what's at risk there. And so I don't know that one is necessarily better than the other. If I own two properties, they're in trust, and I've got an LLC that's the manager, or I got an LLC that's the beneficial interest holder of that trust, or whatever the case might be. I want to have an LLC behind it. If I've got 5 properties, there's no way I got 5 LLCs. I'm going to have 5 trusts and 1 LLC above those that's going to be the owner of those trusts. That way I have LLC protection, and I have that shielding of my identity, and I have a manageable cost, and I don't have to file things every year. That's what works best for me. And I'm really trying to pitch whatever's best for you. I'm not trying to, I don't think anybody should come out and say, you have to do this, you have to do that. You just don't. But, for me, that would be my best structure. That would be my best setup. And for me personally, I hold my rental properties in land trusts.
And so Yuri said, would you recommend transferring your real estate LLC to a trust for the better taxation, legal benefits, etc., or just keep the LLC instead of transferring the trust? We kind of already answered that, but I don't know if you want to hit on the tax side, maybe.
Yeah, I think that well, you don't have to recognize that tax form. It's just the income goes wherever the income goes, and it may go to you personally or it may not. So you might have a real good reason for why you would want to pay some tax through an LLC. And that's really kind of a tax person type question. And somebody for the tax advisors, something for them to answer. So, I don't know that it would be best to transfer it out. I just know that trusts are just a much easier mechanism for holding the property, and less, and you don't have to do any tax filing on that. You would just show, I got this much rent income, and I would just show that on my tax return, whatever that income happened to be after my expenses. And I don't have to file a separate document. So that I like that ease a lot. And for a guy like me, it makes a lot of sense.
Yeah. And then Eric, I think a lot of people get confused because there's so many different kinds of trusts. He's saying our land trust, the same thing as what's called, is what is called trust. I mean, there's trusts are like lots of things. There's many kinds of trust. And you want to just you want to just hit on like maybe where a land trust is just slightly different.
Right. I mean, in my definition on the land trust is it's kind of a single purpose trust for the purpose of holding real property. It is a revocable living trust, and it can be revoked at any time. And it has those three entities: the trustee, the beneficiaries, and the person that set it up. They've sometimes called Illinois land trusts. They are called passive holding trusts. They are sometimes called land trusts, real estate privacy trusts. They have a multitude of names and are marketed a multitude of different ways, but they're kind of like this single purpose holding revocable living trust. And I think land trust is probably the most generic statement for it. But I want to make sure that everybody understands it is revocable. You can revoke it.
That's key.
Yeah, so it's not an irrevocable, and you're not stuck with it forever. If you want to get out from under it, you can get out from under it at any time, or change it or modify it depending upon what your life situation happens to be.
And then Eric asked one that you kind of already hit, but do trustees normally get paid for their duties? Do you get paid when you're a trustee?
Yeah, usually it depends on the amount of effort that you want your trustee to undertake. I think most trusts call for about $150 a year. And that's probably pretty generous given what you don't do, because most trustees really are just meant to be seen and not heard. You really don't need any activity on their part. Once in a while, some mail might come that needs to get forwarded, but there really isn't a lot to do. It is a passive entity trust. It's intended to be passive. And so, if it were a friend, they probably wouldn't charge you anything. And I wouldn't charge a friend anything to do it. There's nothing to it.
Sal asked, does an LLC and trust help in, this is a good one, help in the case of somebody going to assisted living? Now, remember, these trusts are revocable, which is the key answer to your question. So I'll let you handle that one.
No, and that is the key part, because the problem with a revocable living trust, land trust or a revocable living trust, is that if I can revoke it, my creditor can revoke it. And so the key to these are to shield the privacy. The keys are to shield that you own it. If the person going into the residential home, they might have forgot that they own it. I don't know what they've forgotten or not forgotten. But again, it can be revoked by a potential creditor if they are aware of it. They can invoke the revocation clause. And so the key would be to not let it be known, to not let it out, to not let anybody find out, and certainly not volunteer the information. But yeah, there is a potential that it could be revoked. An LLC, on the other hand, would be a little bit different than that, because you can't just willy-nilly revoke an LLC. You have to have the managers vote on it. And if I'm going into a home and I own an LLC, I'm probably going to join my kid as a member before I go in there. And my kid is probably going to say, no, I'm not going to do that. I'm not voting to shut it down. I'm going to keep it alive, Dad. And I'm going to say, no, you need to shut it down. And he's going to, no, I don't have to. You give me a 50% ownership. And so he would have the ability to stop that. And the rest home would have the inability to take it away. They could only get at my membership interest. And that LLC is never going to be profitable again, because my kid's going to make sure that he runs it into the ground. So
I like that. That's part of winning the war right there. Just know that the war is coming and figure out how to win it. All right.
He's a good kid. So.
What is the cost of forming a trust, like a land trust?
I think the basic fees are somewhere around $695, $700.
That's exactly what I used to pay. $650 is what I paid for mine. Yep.
I think that's about right. And that is a one-time cost, which is really the big sales point of that, is that it's a one and done.
So it was a little less than setting up an LLC, which is why we were doing that when we were wholesaling. In wholesaling, we didn't do it for every property, but we did it for a lot of them. And the LLCs we would use for all the properties we held, whether that was right or wrong. That's just the way we were doing it. Let's see. So we got that. Do the properties in the trust have to be in the same state as where the property is located? And what happens if the properties are spread across several states?
That's a great question.
Mhm.
They don't have to be in that trust, can be domiciled wherever that trust happens to be domiciled. So my basket is sitting wherever my basket sits in whatever state it happens to be sitting in. There just happens to be a deed for some property that's sitting in the basket, and that property might be out of the state. It doesn't have any control over it one way or another. So I can put out of state property in a trust that I'm holding, sitting in New York, wherever I happen to be. That trust would control it. Again, we're going back to contract principles. It's just a contract that establishes this basket, and it's just holding real property. And so there aren't any real regulations I have to abide by on one state to the next. A lot of states push back this, that, or the other. But the reality is the contract or the trust can hold property anywhere that you want it to. And despite the fact that I don't recommend it, I can have two properties from two states sitting in the same basket. There's no prohibition of that. There's no rules or requirements. The contract controls and dictates the terms of how the trust is to be administered. And that's what we all look to. And so it just happens to be administering the property in different states. So
great. And then Yuri said, define owning nothing and controlling everything in real estate.
Well, on public record, I would have my name would pop up as the Kurt Harris as the trustee of the Lazy Dog Trust. But my client is really the owner of that. And my client has a contract with me that I'm to sit there as the registered owner of this property. Everybody looks at me as though I own it. If you do a property search, it looks like I own it. But the reality is those proceeds are going into an account that my owner controls. And my owner is the one that's managing those profits while I sit out here as the front man on the property. I really don't own anything. I don't have any interest in it whatsoever. And I have no equity in the property whatsoever, but somebody else does, and they're receiving all the profits. And for my efforts, I'm given a few bucks to sit out there and essentially do nothing, but kind of be the target for anybody who may want to bring a lawsuit. And so, and then I am never going to say, unless I get a court order that makes me say, I'm not going to say who the owner is. I'm just not going to do it. And there's no reason to, and I got a contract that tells me not to. And so I do understand that part of the contract, and just don't disclose. And so that's kind of that whole process and procedure is that, the company, it owns a car, it's a company car, it's not my car. Yeah, but you own the company. Yeah, I understand that, but you don't know that. All you know is that the car is owned by the company and then I drive the car. And so that's that whole, I control it all, but I don't own any of it. I'm always putting it onto the third party. The trust owns the land, the company owns the car, company owns the trust owns the land. It isn't me, it's somebody else. And I'm not responsible for any of it. My manager is, or my trustee is.
Okay. Ronnie said, why wouldn't you just create a Massachusetts business trust, control everything without needing permission from the state, like with any corporation, and then putting the business trust under an irrevocable trust?
That certainly is one way that you could do it. I mean, I find no fault with that idea. And I love the irrevocable. Now you brought in irrevocable
now
trust
you're protecting
the mix here now.
Exclusively.
So as we move our way up the chain, as we attorneys get over the hurdles, now there's an irrevocable trust out there that I can't pierce. As long as you've managed it properly. The issue that people don't like about irrevocables is that unless you build a back door into the irrevocable, you have to give the property away. Right. And now you don't own it. You do not own the property.
Yeah. And those kind of trust setups cost a little bit more than $650. Start getting into that stuff. I remember when I was an advisor, we did a whole bunch of Medicaid planning and, we got into grats and all sorts of stuff. I mean, the average bill for those clients trying to set up those systems of trust and grats probably ran in the neighborhood of $20,000 to $40,000. So Ronnie, great suggestion. Just you just climbed the ladder to another level of protection and also another fee structure built into that. So we're just trying to kind of keep it ground level, make it super simple for people to kind of have these nimble, trust that they can use in and out. But for what you're doing, Ronnie, knowing your situation, that probably would be a better situation because you got a little bit more to protect there. Yuri, what is the, oh gosh, this could be a whole training in itself. What are the different trusts? Revocable, irrevocable, and then from there, it just gets crazy.
Yeah, I mean, really, if you just break a trust down, basically, there is a revocable and irrevocable. In those subcategories, you just have like your personal revocable trust, you have some land trust, there are some Medicaid trusts and a few other types of trusts that you can set up that are more along the irrevocable side of that. And then there are several irrevocable trusts for tax purposes that people get into when they want to devalue their estate by transferring property out of their estate and into their irrevocables. They have a lot of names. I'm just going to say for the record, most of those are marketing ploys by attorneys to try and generate or make money. I hear these things called spendthrift trusts all the time. I just want you to know that all trusts should have a spendthrift provision.
Right.
And spendthrift means if I'm the beneficiary of a trust, I can't pledge my future inheritance as collateral on a loan. That's what a spendthrift provision is. That's all that it is. But I know that they've created this big spendthrift trust for, that for sales purposes. But all that is that I just can't pledge the collateral. And that's really all that it means. But I will just say most of them are boiled down to revocables, irrevocables, and they can be tailored within that. But that's kind of it. Land trust is really kind of a single purpose revocable living trust.
Yeah. And then Don said, is a trust better than a TOD, transfer on death, for primary home?
Okay. Good question. I think it is. But a transfer on death on these deeds, they work fantastic. And I can list that it'd be transferred on death to any beneficiary that I want to. I just want to make sure that it's understood that when I die, that property is conveyed 100% to the person on the deed on the date of death. If you want to have any controls over the person, if you want to distribute it out to several individuals, if you want to maintain some control beyond the grave, you need a trust to do that in particular. And some people get a little edgy about putting other people's names on their deeds. I know I personally do. I know that, I love my father dearly, but he might incur liability that I may not want to be on the same deed with him. He loves me too, and I might incur liability. He may not want to be on the same deed with me for asset protection purposes. So transfer on deaths are excellent mechanisms for transferring a single piece of property, single purpose. It doesn't handle all the other items that you might have out there that a revocable living trust might handle, but it would be similar to a real estate privacy trust or a land trust, but it gives you zero privacy.
Elena has a good one, and this is, kind of getting into mineral rights. She says, is this the same if a home is owned outright? And how would I hide my mineral rights I have?
You can potentially put mineral rights into their own
the rights themselves.
Yeah, they are individual rights. You can put those into an LLC if you wanted to. For the profits to be paid to that LLC, you could put those into a trust with the profits to be paid to an individual trust. If you wanted to set it up that way, you can separate the two without any issue whatsoever. It would just show who is receiving what profits, and then you would set up an individual bank account for each of those. I think that would be an excellent way to set things up if you were receiving a lot of the dividends from mineral rights. I think that would be fantastic and a super good idea. And again, would shield the owner of the mineral rights.
That's great. Eric, would putting multiple properties into one trust that is owned by a single LLC have the same protection as the other way around, multiple LLCs in one trust? I'm just trying to balance asset protection and being practical about operational costs. This is kind of what you hit on earlier in the training.
Yeah, I would prefer multiple trusts feeding a single LLC because you still get the LLC charging order protection. And then you have multiple trusts separating all your baskets. We don't want people leapfrogging from, and we talked about this from the series LLCs too, from one trust to the next. Oh, you own this trust and it has all these properties in it. Now I'm going to try and execute on my judgment on all of those properties. Whereas, look, I own this property. It's in the Lazy Dog Trust. That's it. I don't have anything else. There is nothing else that I can remember that I have today. That's it.
Yeah. The cost would be less. Your CPA would certainly like you better doing it that well. Maybe your CPA would like you less, depending on what kind of CPA. I mean, they might be charging you more and more just for filing fees. So yeah, I think that's solid advice right there. All right. James, we kind of already hit, it's kind of funny, almost like you saw this. Does a spendthrift trust deter a lawyer or add another lawyer up, or another layer of protection for the LLC?
Not a bit. It invites me. It means nothing.
Yeah.
I can set that. I can revoke that trust. I can do that. So, and you know, people shouldn't be extending credit based on it anyway. You know, shame on you if you do, because it's that fool me once kind of situation. So no creditor should ever extend any credit on a future inheritance. It's a very bad idea.
Yeah.
So
Eric, this poor son of a pup lives in California, and he says, are trusts subject to the self-employment tax?
You know, I grew up in California. If California finds out about it, yeah, okay. There is no reason for them to know anything about that. And there's no reason, it's not public record, and there's no reason to tell them. And if they do come around, no, they are not. Individuals are, but trusts are not. A trust is really just an arm of the individual. It has no independent responsibility. Now, you at the end of the rainbow might have some self-employment tax issues, and California will always tell you you do. They will always tell you you owe the money. They always tell you to pay first, and then we'll talk about it later. That seems to be California's means of moving forward, is that the tax is owed on everything, always, outright.
I'm always really thankful, you know, for the people that live in California, because, you know, sometimes I just think I've got it the worst living here in New York. And then I think about those poor people that live in California. By far, you all take the cake. So thank you for at least making New York the second worst state. And that could be up for argument, but I'm sticking with that story. The order said, like an LLC, should trust be formed before starting business? I think so.
Preferred. Yeah, absolutely preferred. If they aren't, your name might be on public record. And then, like I said, it blips off the radar. I'm suspicious you transferred into a trust, but that's not going to get me there necessarily. So there's never a bad time to make the transfer. You can always make the transfer. It looks odd, but then again, you don't owe me an explanation. You don't owe me anything. So if it comes off, it comes off, and you may have sold it or may not. I don't know. So there's no time like the present to make the transfer. Always best to enter in from the get-go. I never saw your name.
All right. And Ronnie was the one with the irrevocable trust. He said, why would you create a revocable trust when an irrevocable gives you most control? You can always modify the irrevocable and no one can pierce it other than the creator. So I would have the question about the most control. It gives you the most protection, but not control. Maybe,
yeah, I mean,
don't know.
There's a couple of revocable trusts or irrevocables out there that can be modified, but for the most part, they cannot. And if you are doing the irrevocable by the book, you have to divest your estate of that asset. And essentially, you've given up all control and it gets its own tax ID number and it pays its own taxes, and it's no longer part of your estate. It is asset protected, absolutely, but you are not allowed to be a beneficiary of an irrevocable trust. And my whole point is, I need this rental income. This is how I live. This is how I make my money. I'm not in a position to just give it away at this point and pass that on to the next generation, have it pay its own tax. And so I think that's more advanced or further on in my particular life. There are some revocables that can be amended. I don't know if they've all been tested across the board, but there is a potential for that, but it's not the norm. It's not what's normally out there.
James said, when transferring personal property into an LLC, will that property will be reassessed and show as sale versus a straight transfer, thus keeping taxes out of the issue?
Yeah, usually it could be reassessed if it goes to an LLC. Chances are it won't be, though. I don't think that that's the norm or the standard. There are a lot of jurisdictions out there that are trying to claim and charge transfer taxes, which you might get by going into Philadelphia is really Pennsylvania. I have a lot of trouble with Pennsylvania and transfer taxes. If you go into a land trust, there should not be any transfer tax. If you go to an LLC, there is a transfer tax that can be charged in many jurisdictions. So it's something to look at before you make that transfer to an LLC. But a land trust, there should never be a transfer tax, although they do try to charge it. Don't get me wrong. They want your money.
Good advice. Yuri said, would it be wise to name your trust and LLC something that does not have your name or family associated with it, so it remains private and out of sight?
Yeah, for me, my preference is very much to use the 123 Elm Street Trust or wherever that property happens to be. We attorneys, that's just totally amorphous to us. Well, I already knew that's where the property was. And that's the name of the trust, the 123 Elm Street Trust. Okay, I get it. It doesn't tell me anything, and yet it tells you everything. For you to keep your property straight, you know exactly which property is in which trust, and I do prefer that. Or anything out there under the sun that's not related to you will work. And there are no copyright infringements. It's not a public document, so you can call it the Mickey Mouse Trust if you want. Disney's not going to come down on you. Whatever you want to call it, you get to call it.
All right. Anita said, what if you are renting to live in, want to stay as a renter, but want to purchase a property or properties to rent out and or keep one of them as a vacation home? Okay to keep all properties in a land trust? This is Grant Cardone. That's what he teaches.
Yeah, definitely okay to do that. And then, you can have your renters, you can set up a property management company by way of an LLC or something if you want to have them pay the rent, or you can have them pay the rent to the trust. They never need to know who you are. Again, you're going to be the landlord, you're the property manager or whatever, but they don't need to know you're the owner. No one needs to know that. And so you have the ability to maintain your privacy that way. You don't have your tenants saying that they want a leak fixed or whatever that happens to be all the time because they know who you are. You don't have that familiarity with them. And yet they can still pay their rent to the account that's set up in the name of the trust or to an LLC, however you want to set that up.
And then Jameson said, if you flip lots of properties, should you put the property under a land trust, as some properties take longer to rehab and sell?
I think it's a lot cheaper. And you do eliminate any potential deed restrictions that you might have in the flipping process. And if you're flipping through the LLCs, flipping properties, it's a little more expensive. If you've got an outside investor with you, somebody who's not a family member or something like that, I may not want to be in a trust with them, and an LLC might suit me better. It might be best for us to have all that down in the percentages of ownership and the liabilities. If I'm doing business with other individuals who are outside of my family or aren't that close of friends with whom I may not want to be a member of a trust with or a co-owner of it. So those are some thoughts you may want to go through as you do your flipping, what might work best for you.
Fantastic. All right. We got through 34 questions there, folks. And those are some good questions. Great job. That was awesome. And it was a lot of repeat, but a lot of great info right there, folks. And Kurt, thank you so very much for your time. Just a wealth of knowledge. And I love the way you did it from both sides of the coin. It's a perfect way to have our minds wrap around it. And, can't wait to have you back on.
Thank you very much. I appreciate it. It's great.
You're welcome. You're welcome. And if you guys liked this video, you got to check out the next one and make sure you subscribe to this YouTube channel. And hey, don't forget, make sure you smash the alerts button. See you on the next one.